So good morning. Sorry. Good morning, everyone. We are here at one of the semifinals from the Rio Pre Moot. Welcome to all of the teams and congratulations for reaching this high step of the way. So as we were informed, the pleadings will start with the respondent addressing the procedural issues for 14 minutes and then an answer, then a rebuttal for 1 minute, each one of the teams. So I'm going to give the floor to respondent now, which is Marseille. I don't know who is going to speak first, so please.
This is me. My name is Emma Biancucci. Honorable members of the tribunal, good afternoon from France. So my name is Emma Biancucci. I am from Aix-Marseille University, and I, together with my co-counsel, Mrs. Emma Zurzolo, will be representing respondents in today's proceedings. I will address the procedural issues of the dispute, while my co-counsel will address the merits issues of the dispute. In this arbitration, our client, Respondent 1, granted a non-exclusive license to claimant for the use of Gold-Atkin-Barrel vectors, especially in the field of respiratory diseases. And claimant now alleges that our client breached this contract because of a frivolous claim that Roche Pharmaceuticals also has an exclusive license for the same use. And curiously, all of the sudden, claimant strongly objects to Roche's joinder, even though claimant itself requested the joinder of respondent number 2 because it is a patent holder. There was no determinable reason to include respondent 2 into this proceeding, if not to clarify the legal relationship between both contracts. Members of the tribunal, we would like to make two submissions. First, that Roche Pharmaceuticals has to be joined to the arbitral proceedings. And second, that hearing for the witnesses and experts have to be in person. Regarding the first issue, the parties, firstly, in the Respivac agreement and the Roche agreement, accept the entire Swiss rules and the jurisdiction of this tribunal. Secondly, because consult does not mean consent. And thirdly, because of the relevant circumstances the tribunal has to take into account. Firstly, both agreements have the same arbitration clause inspired by the model clause proposed by the Swiss Chamber arbitration institutions. They do not use, for instance, any other model clause as they could. Thus, they accept the jurisdiction of this tribunal. And both clauses are written in the same way, saying in accordance with the Swiss rules. The Practitioner's Guide of the Arbitration in Switzerland of 2018 states that Article 4.2 is not mandatory. The parties can agree to opt out this provision. But if they do not opt out, as Respivac and Roche Pharmaceuticals did, they are deemed to have consented in advance to the joinder and possible consequences. To go further, both clauses are written in a way saying any dispute, controversy, or claim arising out of or in relation to this contract. But the claim between claimant and respondent number 1 is in relation with the Roche agreement. Thus, the party clearly envision the possibility to be joined or to have a joinder if a claim arises. Secondly, consult does not mean consent. Article 4.2 is written in a way saying where one or more first persons request to participate in arbitral proceedings already pending under these rules, or where a party to pending arbitral proceedings under these rules requests that one or more first persons participate in this arbitration. The or in this sentence shows that there are two situations. The first, when the first party wants to join the proceedings, and the second, when a party wants a third party to be joined to the proceedings. Thus, it can be deduced that in the second situation, the third party does not want to be joined, otherwise the or in the sentence won't be needed. To go further, the Practitioner's Guide of the Arbitration in Switzerland analyzes the end of this article, which says, the tribunal shall decide on such request after consulting with all the parties, including the third parties or persons to be joined, taking into account all relevant circumstances. Here, there is no and taking into account, just taking into account. This means that consult and all relevant circumstances has to be taken into account jointly by the tribunal in order to decide on the joinder. So even if Ross Pharmaceuticals or claimant opposed to the joinder, the tribunal may allow it if the relevant circumstances here show the necessity to join Ross Pharmaceuticals. Thirdly, the rule.
Counsel, if I may, please.
Yes.
But getting back to consent or to your first argument, how can you convince the tribunal that between Ross Pharmaceuticals and claimant, is there an arbitration? There is an arbitration agreement. Isn't there the need of an arbitration agreement between claimant and Ross Pharmaceuticals in order for Ross to be obliged to join these proceedings?
No, Mr. Arbitrator, but here in both clauses, the parties consented to have Article 4.2 applied to her because they accept the entire Swiss rules and the jurisdiction of this tribunal especially. So they envision the possibility to be joined in any dispute or claim, or to have a person join in their disputes. And to go further, this clause is written in a way any dispute, claim, controversy arising out of or in relation to this contract. And those clauses are the same in both contracts. So the scope of the arbitration clauses are very large and can envision Ross Pharmaceuticals to be joined to these proceedings. Thus, the tribunal has jurisdiction. So, thirdly, the relevant circumstances here show the necessity to join Ross Pharmaceuticals. First relevant circumstance. May respondents invite the tribunal to look at the Notice of Arbitration, page 8, paragraph 27. Please give me a sign when you arrive at this extract.
27?
Yes, exactly. Page 8, paragraph 27. Claimant claims that respondents didn't abide by Article 42.1 of the CISG, but on what basis? This paragraph starts with, according to the interpretation of the Ross Agreement by Ross Pharmaceuticals. So even claimant in its own notice of arbitration, in order to accuse respondents, need the interpretation of the Ross Agreement by Ross Pharmaceuticals. This is the first clue that shows that both contracts are intertwined in this dispute. And to go further, whatever the outcome of this arbitration will be, this award will impact the Ross Agreement. What claimant and Ross Pharmaceuticals want is to find an efficient COVID-19 vaccine based especially on the go.com viral vectors, to produce it and commercialize it. The profit each party could have is enormous. Thus, they want the same thing in order to have the exact same outcomes. So what would be more efficient than joining Ross Pharmaceuticals and binding this party to this award while taking into account the entire framework of this dispute? Regarding the second issue, the tribunal has to opt for in-person hearings for the examination of witnesses and experts. Firstly, the arbitration clause in the Respivac agreement states that in-person hearings should be held. Secondly, remote hearings threaten the confidentiality principle, especially in this dispute. Firstly, may respondents invite the tribunal to look at the clause 14.1, page 16 of the record, paragraph 3. Please give me a sign when you arrive at this extract.
Sorry, which page?
Page 16 of the record, clause 14.1.
Bianucci, I'm sorry, but you were going to make two arguments on the hearings in person. The second one is the confidentiality. And for the sake of my notes, how did you title the first one so that I can keep myself organized?
The first argument is the clause in the Respivac agreement clearly states that hearing in person will be held.
Okay, thank you.
So the paragraph 3 of the clause 14.1 in the Respivac agreement is written in a way saying hearings should be held at the arbitral tribunal's discretion, either in Vildobona or in the city where the respondent has its place of business. This is a clear assumption that hearings shall be held in person. this sentence was added to the model clause especially, and claimant accepted it, this sentence as fair, as it is stated in the procedural order number 2, question 42. Thus,
but Madam Biancucci, this wording was done before the COVID-19 pandemics, so the situation changed a lot since it was written.
Exactly, Mr. Arbitrator. First, claimant accepted this clause as fair and do not want to discuss further this clause. And second, in this contract, the clause 15.3 of this contract states an amendment clause. The party can amend the contract if they want it and can amend every clauses in it. But RESPIVAC never proposed to modify the contract or never wanted to modify this clause or this sentence especially. And on the opposite, claimant accepted it, this sentence and this clause as fair. To go further, Article 25.4 of the Swiss rules states that hearing may be heard by the manner said by the arbitral tribunal. The language in all this article is may, not shall. This means that the tribunal is not bound by a principle of remote hearing. It may be heard. This means that the party can agree differently in the clauses. And if the intent of the party, according to Article 4 of the unitary principle states, the parties' intent clearly here show that hearing should be held in person because they designated 2 physical places in order to have physical hearings. To go further, the Danubia regulated in April 2020 that remote hearing could be held if both parties agree, but respondents disagree. Secondly, virtual hearings threaten.
I'm sorry to interrupt again. Thank you very much. I'm just wonder if your point here does not contradict your first point on the first issue, because on the first issue, you want us to not to enforce the arbitration agreement or to enforce an arbitration agreement that does not exist just by using or applying the Swiss rules. And now you want us not to apply the Swiss rules because there's an agreement of the parties. Isn't this a contradiction in your position?
No, Mrs. Chair, because this article is written in a way using may, not shall. This article is not mandatory, and the parties can agree to opt out differently as they opt out differently in these clauses. Thank you.
So your point here is that they did not opt out regarding the first issue, joiner, but they opt out regarding virtual hearings. Is that your point?
Yes, while adding clearly this sentence to the model clause, and claimant accepted it clearly this sentence as fair, as it is stated in the procedural order. Thank you.
Thank you very much.
Secondly, virtual hearings here threaten the confidentiality principle. Claimant generated public interest due to its groundbreaking Go.com-based vaccine. The Forbes article on February 2021 states that the Oxford University biology laboratories, which make especially research on COVID-19 vaccines, has been hacked. Secondly, a BBC article on January 2021 states that vaccine data on coronavirus was stolen from the European Medicine Agency. Thus, the COVID-19 vaccines data are a perfect target nowadays for cyber attacks. And to go further, a CBS News article on March 5th, 2021 states that due to COVID-19 crisis, a real and enormous market has been created in the dark web in the sole aim to sell vaccines and research on COVID-19 vaccines. Thus, COVID-19 vaccines are a perfect target for cyber attacks. And this is the reason why respondents signed written 2 arbitration clauses in both contracts because of the overwhelming principle of confidentiality. But the procedural order number 2, question 45, states clearly that it cannot be excluded with 100% certainty that no third party may interfere and get access to the hearing. I see I'm running out of time. May I ask the tribunal for 2 additional minutes in order to wrap up my arguments and conclude?
If my colleagues arbitrator do not oppose, I think you can.
Thank you. So the procedural order stated that it cannot be excluded with 100% certainty that no third party may interfere and get access to the hearing. And this is especially true in this dispute. First, the security manager used. The Moot uses the International Dispute Resolution Center platform, which uses Opus 2 as security software managers. Opus 2 has the ISO 27001 certification for data protection and confidentiality. But the University of Wolverhampton Business and Technology Center's website clearly stated that this certification does not suffice. This certification does not have a support for threats and cannot ensure that no third party may enter in this platform. Second, the software used. The software used is Zoom, the software that Apple removed to its Mac in 2019 after serious security vulnerability. The software that The Guardian in May 2020 qualified as a privacy disaster. The software that the BBC, on an article in April 2020, states that a former National Security Agency hackers identified a series of issues, including a flaw which left Mac users vulnerable to having microphone and webcam hijacked. This software is not secure enough, according to the dispute here, to the fact that here, this is an efficient, unusual COVID-19 vaccine that we will talk about. And the 2020 International Bar Association Guidelines on the Taking of Evidence, Article 2 states that the tribunal has to take into account any issues of cybersecurity and data protection in order to decide on the hearings, is that we will held in person or remotely. Respondents respectfully submits that Roche Pharmaceuticals has to be joined to the arbitral proceedings because it is a non-negligible element to the dispute, which will permit to have an efficient dispute resolution, and submit that hearings should be held in person because of the Zoom software and the security manager weakness, and the fact that this dispute is a perfect target for hackers nowadays. This ends my submission. Thank you.
I have a final question, just to make a clarification. The argument on the cybersecurity was very interesting, but I want to make sure if all of those very sensitive information will truly be discussed on this case, because we can understand that the case can be resolved closer to the words of the contract and not closer to the science behind of the COVID-19 vaccine that has been done. So if the lawyer could address the sensitiveness of those information in regards specific to this case, it would be of value.
Yes, Mr. Arbitrator. First, in page 49 of the record, it is clearly said that these hearings for witnesses and experts may entail difficult explanation about the operating mode of viral vectors and their way of production. And this COVID-19 vaccine has a special way of production because it is produced with HEK 294 cells, not HEK 293 cells. And those explanations are very complex and scientifically complex and confidential. This is the reason why respondents signed an arbitration clause in both contracts. And this explanation will permit for the tribunal to understand the whole framework and the scope of both contracts. So this is confidential, and this is the reason why respondents especially want in-person hearing only for witnesses and experts, and not for lawyers, for instance, as we are in a virtual hearing today.
I have also an additional question. To the very end, you mentioned IBA rules. Could you explain briefly why or in which manner these IBA rules apply to this arbitration?
Yes, Mr. Arbitrator. The IBA rules, as Redford and Hunter quoted it, is a universal guidelines. It is a guidelines not binding the tribunal, but it is an important guidelines recognized in the world. Thus, this guidelines, it was made in 2020. So it is a recent guideline that takes into account the new framework and the technology side of the hearings. And these guidelines especially decide that the hearings remotely could be held, but the danger of cybersecurity and data protection are really important too, especially in this dispute and not in all disputes. And this is the reason why I use these guidelines, because it is a universal guidelines, as Redfern and Hunter quoted it.
Thanks.
Thank you.
Thank Thank you very much. If there are no more questions, any more questions, I'm going to move forward to claimant now. So I just give the floor to, I don't know, Milena? Okay.
Yes.
Please, counsel.
Thank you. Members of the Arbitral Tribunal and counsels for respondents, good afternoon and good morning. My name is Milena Prestes, and I'm here to represent the claimant in the procedural issues in the case Respivec versus Camvir and Vectorvir. Members of the tribunal, I will answer my opposing counsel's submissions and refer to this tribunal's concerns by stating, first, that Ross Pharmaceuticals should not be joined into this arbitration, and second, that the second hearing should be remotely conducted. In relation to the first submission regarding the joinder, opposing counsel stated that Ross Pharmaceuticals should be joined for three main reasons. First, because all the parties and Ross Pharmaceuticals agree with the Swiss rules joinder provisions. Second, because consult does not mean consent for the purpose of Article 4.2 of the Swiss rules. And third, because of the relevant circumstances of our case. We would like to clarify for this tribunal that we agree with the opposing counsel in relation to the first and the second arguments. First, the fact that all the parties agree to arbitrate the disputes under the Swiss rules means, and I quote what the opposing counsel stated, that they envisioned the possibility of being joined, unquote. And secondly, that consult under Article 42, Article 4.2 does not require express consent. However, members of the tribunal, in order to admit a concrete and not a possible joinder request, disregarding the objection of the third person and one of the parties of the arbitration, the tribunal must firstly determine if it has jurisdiction over the third person, meaning that the arbitration clause giving rise to the proceedings must be extended to the third person. This position was supported by a commentator of the Swiss rules, namely Philippe Guilherrion from the University of Lausanne, that sustained that under Article 4.2, it has to be determined whether the third party can be regarded as a party to the arbitration clause and whether an extension of the arbitration clause can be accepted. This position was also supported by the Singapore Court of Appeal in the PT First Media case. We acknowledged that in this case, it was not decided under the Swiss rules, but the SIAC rules. However, this case is relevant because the court analyzed different joinder provisions laid down in different arbitration rules, including the Swiss rules, and concluded, and I quote, that the consent under an arbitration agreement to arbitrate in accordance with a set of institutional rules does not mean consent to a forced joinder, because any set of arbitration rules could provide for such unlimited jurisdiction. Members of the tribunal, as affirmed by opposing counsel, there is no arbitration agreement between claimant and Ross Pharmaceuticals. Ross Pharmaceuticals never agreed to arbitrate its disputes with claimant, nor claimant agreed to arbitrate with Ross Pharmaceuticals. And this is why the tribunal does not have jurisdiction over this third party that should not be joined. Also, addressing the further arguments brought by opposing counsel, we shall see.
Can I just interrupt you there? Sorry. But
yes.
The issue that is going to be discussed, which is the scope of the Ross agreement, isn't that issue included on the arbitration agreement that exists between Camvir or the other respondent number 2 and Ross Pharmaceuticals?
Madam Presiding Arbitrator, we should highlight here that are two separate arbitration agreements that do not relate to each other. Each arbitration agreement is independent, it is on different and unrelated contracts, and cannot be considered a basis for the tribunal exercising jurisdiction over a person that has never consented with this arbitration clause, the giving rise to these proceedings. Ross Pharmaceuticals never agreed to arbitrate with claimants, and the opposite is also true. And this is a relevant circumstance that the tribunal should consider in order to disregard the joinder request made by respondents. Opposing counsel, in the third argument regarding the relevant circumstances, brought the tribunal to page 8 of the case file, where is the notice of arbitration. In light of this, I would like to bring also the tribunal to this page, page 8 of the case file, paragraph 27.
Paragraph 22nd.
27. The same paragraph that was mentioned by opposing counsel. Members of the tribunal, opposing counsel failed to read the entire paragraph. If we see in the second and third line, and I quote, whether this is actually the case, as respondent number 2 press release seems to imply or not, is irrelevant, unquote. Members of the tribunal, in these proceedings, we are not discussing the scope of the Ross agreement as opposing counsel addressed it. We are only evaluating the existence of a claim prior to the conclusion of the contract. This already amounts to a violation of Article 42 of the CISG, and Ross Pharmaceuticals could not provide this tribunal with legal evaluation of whether we have a claim or not, and thereby would have no use for the resolution of the dispute. Here, members of the tribunal, in order to assert if respondent number 1 breached its contractual obligations, the tribunal is not being prevented without the Ross Pharmaceuticals. The tribunal can make this decision without Ross. In 2015, in Agro-Invest Bank versus Super Perfect Investments, a sole arbitrator dismissed a joinder request because the joinder was not essential. This case is similar and relevant. Similar because in that case, the third person also had a contract relationship with one of the parties to the arbitration, such as Ross Pharmaceuticals has with respondent number 2. And it's relevant because the sole arbitrator dismissed a joinder request under precisely Article 4.2 of the Swiss rules. In that case, members of the tribunal, the sole arbitrator found out that despite the fact that the third person had a contract with the claimant, the tribunal was not being prevented from assessing whether the respondent of the case has failed to perform its obligations with the claimant. And this is precisely what is happening here. The tribunal is able to analyze if respondent number 1 has breached its contractual obligations or not without the joinder of Ross Pharmaceuticals. Since we are only evaluating the existence of a claim and not the scope of the Ross agreement, nor Ross's IP rights over the goods that were delivered to claimant. And therefore, members of the tribunal, for all these reasons, the joinder of Ross cannot be made in this arbitration. First, the tribunal does not have jurisdiction over Ross. And second, Ross's joinder is, yes, Madam Presiding Arbitrator.
It's really difficult for me to understand how the tribunal may reach a conclusion regarding the existence of a claim without analyzing the scope of the Ross agreement. That's what you are saying. So where we are going, I don't know if your colleague on the merits is going to address this, but as you made that point, I would like to understand what is the tribunal going to analyze in order to decide this issue?
Precisely. Madam Arbitrator, as my co-counsel will address in the merits, a claim is an alleged existence of a right. And in an email exchange between Ross Pharmaceuticals and the head of the contracting department of respondent number 1, Ross already alleged that it believes to hold an exclusive right to use the GORAD chem for respiratory purpose. This already amounts to a violation of Article 42. And even if the tribunal wants to find that the claim has merits or not, it can conduct a legal analysis on the scope of the Ross agreement without making a rule on this contract. The Ross agreement is already on the case file. We do not have to bind Ross to the award to make such decisions. And therefore, we can see that Ross's joinder cannot be made in these proceedings. Now, in the event Ross joins this arbitration, respondents already stated that they will have to present evidence to prove that the exclusive license granted to Ross does not extend to respiratory diseases. And for this purpose, the second hearing is being scheduled to occur. What leads me to the second issue, that the second hearing should be remotely conducted. Opposing counsel mentioned that the tribunal should not order the conduction of the second hearing remotely for two main concerns. First, because of the parties' agreement, since the parties already agreed to hold the hearings in Vindobona or in the city where his opponent has its place of business. And second, because of the confidentiality. In relation to the first argument, members of the tribunal, yes, we agree that Article 25.4 does not impose a rule to conduct remote hearings, but Article 15.1 of the Swiss rules grants the tribunal a broad power to decide the conduction of the proceedings in such manner as it considers appropriate. And Article 15.7 obliges all participants, including the arbitral tribunal, to avoid unnecessary delays. And opposing counsel seems to be forgetting that we are living in a pandemic when addressed the issue of the parties' agreement. Members of the tribunal, as now, the development of COVID-19 is still unknown. Even after the great medical advances in the combat against this pandemic, we cannot overlook the fact that COVID-19 has already shown variants throughout the world, which implications are unpredictable. Refusing to conduct the second hearing remotely means to significantly postpone the resolution of this case for an undetermined timeframe. In 2003, in Videocon case, the Delhi High Court considered to be reasonable the fact that the tribunal changed the venue of arbitration from Kuala Lumpur, as enshrined in the arbitration clause, to Amsterdam because of the epidemic of the SARS epidemic that was occurring in that situation. Then the tribunal exercised its powers without neglecting health concerns or the interests of the parties. And members of the tribunal, on top of that, we should highlight that we are already in a remote hearing. If we would blindly follow what the parties have agreed in a completely different scenario when there is no pandemic, no COVID-19, this hearing would have to be foreclosed. We were not supposed to be discussing, as we are here today, proving that remote hearings are a concrete possibility and that the tribunal has the power to conduct remote hearings. Opposing counsel also raised concerns regarding the confidentiality, since others may interfere and get access to the hearing. Members of the tribunal, in this regard, the CPR protocol on cybersecurity in international arbitration may be selected by the arbitral tribunal as a soft law to help the tribunal to identify measures to be taken into this matter. These measures can include, for example, the use of softwares to generate, store, and manage passwords, as well as the use of biometric tools to control the access to the hearing, and thus ensuring the confidentiality and preventing loss of essential data. This is actually a concern by the arbitral tribunal and by claimant and the respondent, but it's not a problem that cannot be solved when using these protocols and other protocols that are in international arbitration. But on the other side, it is essential to claimant to have this decision as soon as possible and to have this hearing conducted as soon as possible. Members of the tribunal, if we wait for an in-person hearing, the closest opportunity would be by September due to conflicting schedules. But by September, several countries would have already selected actually their primary vaccination source, and others such as Israel would have vaccinated the entire population by March. And if we wait for an in-person hearing, and considering that the second and the first dose of COVID-19 vaccine need to be from the same provider, claimant's product on the market would be void of importance. And this is why it is so essential to claimant to have this decision as soon as possible. And if I cannot be further assistant to this tribunal, claimant ends its submissions, namely that Ross Pharmaceuticals should not be joined into this arbitration, and second, that the second hearing should be remotely conducted. Thank you.
Thank you very much, Counsel. Just a brief question from my side regarding the issues that are going to be discussed in the hearings and the confidentiality issue that was raised by the respondent. My co-counsel just asked before if there are going to be issues in discussion regarding technicalities of COVID and the vaccine, sorry. So, and you did not address that point. So do you have the same concern, or for claimant, the only thing that matters is the scope of the agreement and not the specific details of the vaccine that are protected by the patents?
Madam Presiding Arbitrator, for claimant, it is not necessary to conduct the second hearing remotely because we do not need to assert the scope of the Ross Agreement precisely by bringing such complex evidence. But in the event second hearing occurs, this would happen. And it is, of course, the interest of claimant to prevent loss of confidential information regarding the use of the viral vector. However, we can use protocols to ensure that this won't happen. On the other side, we cannot wait for an in-person hearing that even without concrete predictions of when this may even be. This would also be a problem for claimant and should be avoided. If that clarifies your concerns on this matter. Thank you.
Thank you very much.
I also have a question. You mentioned various times that the circumstances completely changed because of COVID-19. That's certainly true. However, COVID-19 as such is not a legal theory or a legal principle. Nevertheless, and given the fact that you are all from civil law countries and that procedural law here is Swiss law, which is also a civil law jurisdiction, don't we have a legal institution that could eventually empower the tribunal to adapt the arbitral convention, the arbitral clause here? I would like you to help me to find this potential legal basis to adapt. I mean, that's not war, pandemics or unforeseeable catastrophes are not completely uncommon to the law. Don't we have a principle maybe or something in the law that we could apply? Because only referring to changing facts is not a legal argument.
Mr. Arbitrator, we do understand your concern, and it is not claimant's position that the tribunal shall change the arbitration clause under a certain legal theory, but rather that the tribunal shall consider the legal obligation under Article 15.7 of the Swiss rules to avoid unnecessary delays, and opposing counsel could not demonstrate how this delay would be necessary to the resolution of the case. On the other side, it's very essential to claimant to avoid such delay. Is this legal provision that we should take into account?
Thank you.
Thank you.
Thank you very much. Are there any more questions for my colleague?
No, my concern has already been addressed, so we can move further.
All right. Okay. So let's move to the merits. So I'm going to give the floor now to claimant.
I think we still have the rebuttal.
The rebuttal. Sorry. Of course. Thank you very much, Lucas. Yes. Sorry. So rebuttal from respondents.
Concerning the jurisdiction of the tribunal to join Ross Pharmaceuticals. First, without the existence of the Ross Agreement, there would be no arbitration today. Second, claimant, in its own notice of arbitration, paragraph 22, page 7, needs to have the entire Ross Agreement in order to go further on the accusation. So contrary to what claimant argues, both contracts are intertwined and the tribunal has jurisdiction over Ross. Thus, Ross Pharmaceuticals has to be joined. Thank you.
Thank you very much, Madam. It's really hard to say your name. Biancucci. It's not a French name, is it?
Not a French
Italian.
Name. Yeah, exactly. It's Biancucci.
Exactly. Okay. You are what, sorry?
It's Biancucci in Italian.
Biancucci. Okay, thank you very much. And now, claimant, please.
Thank you. Members of the tribunal, Article 42 of the CISG naturally imposes a link with third person and third person's contracts, but it does not have a need to every time of the tribunal asserting if there was a violation of the contract, we need to bring the third person into the proceedings. Otherwise, Article 42 of the CISG would prove to be highly unpracticable, and this should be avoided by the arbitral tribunal by not ordering the joiner of Ross Pharmaceuticals. Thank you.
Thank you. Are there any questions? Just one question for claimant. Well, if the case was in a court of law where you would apply the CISG also, then Ross Pharmaceuticals would be joined or not?
Madam Presiding, could you rephrase your question, please?
So you refer that if we were to accept the joiner request from respondent, that would mean that Article 42 from the CISG would create a lot of complexity in cases. But what I was wondering, if that this was a court's procedure in a national court, in a state court, then joiner would be a possibility without an arbitration agreement. And so, and the CISG, of course, could also be applicable in the state court proceedings. So I was wondering if that argument that you just gave is consistent with this possibility. Was I clear now? I'm sorry.
I think so, Madam Presiding Arbitrator. It is claiming position on this matter that Article 42, for putting an obligation on the seller to delivering goods without third-party claims, naturally impose a link with third person, but it does not mean that every time we need to assert a violation under this in this article, we need to bring the third person into the proceedings. This is what claimant is trying to address to the tribunal.
Okay, thank you very much. So now, Lucas, we can move to merits. Yeah?
Yes.
Okay, so now it's claimant that's going to start. I understood. So UFBA, please.
Thank you. Good morning and good afternoon, members of the tribunal, opposing counsels. My name is Ana Luisa Castro, and I am here to represent the interests of the claimant on the merits of the case. Members of the tribunal, claimant is a startup whose aim is to develop solutions for respiratory diseases, and claimant found a partner in respondent number 1 for achieving this greater goal. However, respondent number 1 concealed a malady in the terms of the contract that could eventually contaminate the entire agreement. And now, as a global pandemic strikes, claimant's greater goal may be hindered. In light of those circumstances, claimant respectfully requests this arbitral tribunal to declare that, first, the CISG is the governing law of the purchase, collaboration, and licensing agreement hereinafter PCLA concluded between claimant and respondent number 1, and second, that respondent number 1 breached its contractual obligations to deliver conforming goods pursuant to Article 42 of the CISG. On the first submission, concerning the application of the CISG to the PCLA, we submit that the agreement constitutes a mixed contract of which the proponent obligation consists in the sale of goods. And this is true from 2 different perspectives. First, according to the economic value criterion, and second, according to the intention of the parties. Members of the tribunal, Article 3, Paragraph 2 of the CISG provides that contracts of a mixed nature, of which the proponent obligation consists in the sale of goods, are governed by the Convention's provisions. In this regard, according to the CISG's Advisory Council Opinion Number 4, an economic value criterion must be primarily used to determine the proponent obligation under a contract. The same position has been supported, for instance, by the Russian Chamber of Commerce and Industry on the arbitration proceedings 356, in which the tribunal decided that the economic value criterion was appropriate to determine the proponent part of an agreement pursuant to Article 3, Paragraph 2 of the CISG. In the present situation, the purchase obligation to buy the HUK cells and cell growth medium constitutes the proponent part of the agreement according to the price composition of the contract. Keeping this in mind, I would like to please ask this tribunal to follow me to page 59 of the record. Members of the tribunal, here on the left side on the green table, we have claimant's internal calculation. The table reads RESPVAC internal calculation. On the middle of the table, we can see production of vaccine, letter A, own production. On the second line, we can see the price of the royalties due to Kenvir, which is respondent number 1. And the prices are, respectively, 1.5 million euros for the first batch, 1.25 million euros for the second, third, and fourth batch, and 1 million euro from batch 5. But when we compare the value of the royalties to the value of the HUK cells and cell growth medium, which is on the line right below on the third line that reads material, batch, HUK 294, and growth medium, we can see that the fixed price per batch is of 2 million euros as established by clause 16 of the PCLA. And consequently, we can see that the price to be paid for the HUK cells is always preponderant when compared to the price of the royalties. And the same is true shall claimant opt to have the vaccines produced by respondent number 1. If we look at the bottom of the same green table on the letter B, which reads outsourced production to Kenvir, on the second line, we can see royalties due to Kenvir. And the prices are, respectively, 1.5 million euros for the first batch, 1 million euros for the second, third, and fourth batch, and 0.63 million euros from batch 5. Hence, always inferior when compared to the price of the HUK cells of 2 million euros per batch as established by clause 16.1 of our agreement. And members of the tribunal, I would like to highlight that this internal calculation dates from 1st January 2019, as we can see on the top of the page, on the top of the appendix. This is precisely the date of the conclusion of our contract, and thus, these values should be taken into consideration when determining the price composition of our agreement. And also,
sorry to interrupt, Miss Ana Luisa. I'm trying to follow the whole rationale here. Okay, so I'm going to step back a little. The premise of the argument is that the sale purchase should be characterized in accordance to the value of the service or of the goods. And you're here saying that the material that's used in the vaccine has a bigger value than the royalties or other services. Maybe that's mainly the point. I follow this, but I understand that this can vary a lot in different industries. When I'm buying a cheeseburger at McDonald's, I am buying meat and bread, but this is a service as far as I understand. And so I want to further address how to identify the sales agreement solely considering the value of the materials inside of something, which can be absolutely immaterial, like a pure license from Zoom and so on. Could you go deeper on that, please?
of course, Mr. Arbitrator, we do acknowledge the mixed nature of our contract. We do agree that there is a licensing part, but there is also the purchase obligation to buy the base materials to further produce the vaccines. And claimant can produce these vaccines by itself, however, is obliged to buy the base materials from respondent number 1. And the main point of our argument is precisely that when we compare the values of the licensing part and the value of the purchase of the base materials, the price of the base materials is always economically preponderant. And moving on to my second argument, that is, also according to the parties' intention, the preponderant obligation under our agreement is the sale of goods. Keeping this in mind, I would like to please ask this tribunal to follow me to page 56 of the record.
Sorry, page 57.
Page 56, Mr. Arbitrator.
Okay, thank you.
Members of the tribunal, here on the clarification number 26, we can see what was the rationale behind the inclusion of the purchase obligation in clause 16 of our contract. And on the first and second line, it reads, and I quote, that the purchase obligation in section 16 was added as respondent number 1 as a contract manufacturer was interested not only in royalty payments, but also in ensuring the use of its production facilities. Members of the tribunal, this can be further explained by the fact that, according to respondent's head of contracting department, it was an internal policy of the company to include in all licensing agreements the purchase obligation, and the rationale behind this can be explained, but for instance, by the fact that, according to respondent number 1's CEO, the real potential of the company consists in manufacturing and selling base materials for the production of vaccines. Thus, the inclusion of the purchase obligation under our contract was of primary relevance for the parties, and thus constitutes the proponent obligation, as the respondent would not have concluded this contract otherwise. And members
sorry to interrupt, but that's the intention of Camvir, not from Respivac. So Respivac was interested in the license because without the license, they could do, if you take out the license from the agreement, so there's no agreement at all. So aren't you focused just on the intention of the respondent instead of both parties?
Madam Presiding Arbitrator, claimant's final goal when concluding the PCLA was to be able to produce vaccines. However, by the time of the conclusion of the contract, claimant didn't have the financial means nor the necessary know-how to produce the H2K cells and cell growth medium that are required to replicate the viral vectors. And thus, we can see that also according to claimant's intention, this purchase obligation was the proponent part, since without that, the vaccine could not have been produced. And now, moving on to the second submission, respondent number 1 breached Article 42 of the CSG by delivering goods that were not free from third parties' claims. In the submission, we will argue 2 main points. First, that a claim existed prior to the conclusion of the contract, and second, that respondent number 1 could not have been unaware of the existence of such claim. Members of the tribunal, the CSG does not provide a specific definition for what is considered a claim. However, according to the teachings of Professor Stefan Kroll, a claim is an alleged existence of a right. And in the present situation, Ross Pharmaceuticals, prior to the conclusion of our contract, had already contacted Mr. Peter Doherty, stating that their company believed that they held an exclusive license to use the gourd-can viral vectors for respiratory purposes. And members of the tribunal, even in the event that this tribunal considers that Ross's claim is not valid, this also amounts to a violation of Article 42 of the CSG. According to the Secretariat commentary, which is the closest counterpart to an official commentary of the CSG that we have, a breach of Article 42 occurs even if the claim is not valid. The Secretariat commentary reads, and I quote, that the seller breached its obligation not only if the third-party claim is valid. In either case, the third party may commence litigation that may be time-consuming and expensive for the buyer, and which may have the consequence of delaying the buyer's use or resale of the goods. Members of the tribunal, it should also be taken into consideration that Ross Pharmaceuticals adopts a fairly aggressive policy in the enforcement of its IP rights against third parties allegedly offending its rights, and is currently involved in 1 arbitration and in 2 litigation against third parties allegedly offending its rights. Thus, the claim already existed prior to the conclusion of the contract and raised a minimum seriousness for it to amount to a violation of Article 42 of the CSG. Also, members of the tribunal, I would like to please ask this tribunal to follow me to page 35 of the record. Here, members of the tribunal, we can see the email that was sent from Ross Pharmaceuticals on 6 December 2018 to Mr. Peter Doherty, and I would like to remind this tribunal that Mr. Peter Doherty was not only the one who led the negotiations of the PCLA on respondent number 1's side, but also on the day of the conclusion of the contract, he was already the head of the contracting department of respondent number 1, and thus respondent could not have been unaware of such discussions since Mr. Peter Doherty was directly involved in them. And if I can be of no further assistance to this tribunal, this concludes claimant's last two submissions, namely that, first, the CSG is not the governing law of the contract, and second, respondent breached its obligations pursuant to Article 42 of the CSG. Thank you.
Thank you. Thank you very much. I don't know if my colleagues have any question.
I have no questions.
Me neither.
So I just have one question regarding the requirements of Article 42 of the CISG. So you addressed the claim issue, the existence of a claim, but I'm not sure if I understood your points regarding the known or should have known requirements that are also provided in that rule.
I apologize if I did not make myself clear, Madam Presiding Arbitrator. What claimant submits is that respondent could not have been unaware of the existence of such claim, since its head of contracting department on the day of the conclusion of our contract was previously directly involved in the discussions surrounding the scope of the ROS agreement. And consequently, respondent cannot be exempted from its responsibilities under Article 42 of the CSG. I hope this clarifies your concerns.
Thank you very much. So now I'm going to give the floor to the other team to respond now.
Thank you. Honorable members of the tribunal, opposing counsel, good afternoon from France. My name is Emma Zurzolo, and I will be pleading on behalf of respondents on the merits issues of the case. Claimant started as a small company which aimed at developing vaccines. An agreement was made between claimant and respondent one in order to help claimant to start its research. More than a year passed without any contention from claimant. However, claimant was then acquired by a leading life science company, namely Corona Life Science, and only then claimant started disputes. So whatever arguments claimant may bring, it appears that claimant is only trying to escape from its contractual obligations as it finds a better bargain with its acquiring company. In this respect, respondent asked the arbitral tribunal to find that the CISG should be applicable to the agreement made between claimant and respondent one, and to find that respondent one did not breach its contractual obligations to deliver good under Article 42 of the CISG. The CISG cannot apply to the agreement owing to the nature of the agreement itself. The agreement is a mixed contract with a license as its preponderant obligation. Article 3.2 of the CISG states that, and I quote, this convention does not apply to contracts in which the preponderant part of the obligations of the party who furnishes the goods consist in the supply of labor or other services. And in this case, the main obligation is the payment for the use of the license. The purchase, collaboration, and license agreements contains a sales obligation for the first Go-At-Cam batch. However, this is not the preponderant obligation of this contract. As my opposing counsel said, in order to determine which is the main obligation, a comparison must be made between the economic value of the obligation on both sides. However, in the present disputes, contrary to claimant assertions, respondents contend that the price structure is too uncertain to be taken into consideration. All the overall amounts my opposing counsel quoted are deeply uncertain. Indeed, those fully depend on whether a vaccine is to be found or not, whether the vaccine will be accepted by a regulatory authority, whether claimants choose to have the vaccine produced by respondent one or produce the vaccine itself, and depends on the amount of vaccine that claimant will sell. The price structure being uncertain, we should look at the purpose of the contracts. According to the CISG Advisory Council Opinion number 4, this criterion includes the intention of the parties as expressed in the documents and the formation of the contracts. My opposing counsel referred to page 56, paragraph 26.
Ms. Emma, can I just interrupt you just to clarify a point? So your argument is that the economic preponderance is on the side of the license agreement, and it's part of your rationale that the development of the vaccine is a service. People are going to develop this thing. But clarify it to me. The payment is only going to be made if the vaccine is successful and it can be negotiated. It can be delivered to patients all over the world. So the payment of the price depends on the success of the vaccine. In other words, it means that all of these services to make the vaccine work, it will not have a direct impact on the pricification of the goods, because either it doesn't exist, so the license payment would be zero, and I might be wrong here, okay? I just want to clarify this. I want to better understand. But if the vaccine doesn't work, the license agreement would pay zero. And if the license works, and then we would follow the Ana Luisa's argument that the cost of the material, it's bigger than the cost of the license. Am I thinking wrong? Could you please help me?
Respondent does not contend that the economic value is on the side of the license. Respondents contend that we cannot rely on the economic value of both sides, as they deeply depend on the circumstances. So we cannot rely on the economic value, and therefore we should look at the purpose of the contracts, meaning the intention of the parties.
Okay, please move on.
So as my opposing counsel referred to page 56, paragraph 26 of the records, we can clearly say that here it is stated that respondent one was interested not only in royalty payments, meaning that this is a mixed contract because there are interest in the royalties payment, but also in ensuring the production facilities. So this in no way shows that the sales of the good is the preponderant part of the obligation. That being said, if I may ask the tribunal to go to page 12 of the record, to the close of the agreement, page 12. It is stated that the scope is about the responsibilities and activities to be performed, the duration and the scope of the rights granted, the exclusive license to the licensed technology, the ownership of intellectual property related to the course of the research and development activities. And
sorry,
only then.
Where in page 12 are we?
It is page 12 at the scope of the agreement. It is close to the scope. So all what I quoted are about the license obligations. And only after it is stated, as well as potential further purchases. Moreover, the parties call themselves licensor and licensee, and not seller and buyer. To respondent view, both parties has attached more importance to the sales obligation, not only according to the terms of the contract, but also considering the behavior of the parties and more importantly, according to the behavior of claimants. Indeed, may I refer the tribunal to page, to the Peter Doherty statement on page, on page 21, yes, page 21 of the records, on paragraph,
Page 21, sorry.
I'm looking for the Peter Doherty statement.
Because this in page 21, I have Rosalie Hubner.
But yes, it's page 13, excuse me. It's page 13, yes. Page 13, paragraph 7, the Peter Doherty statement. Paragraph 7, we can read that the last sentence, Respivac, the claimant, had, however, serious objection against some of the provision and was in particular of the view that the model would not sufficiently take into account the IP element involved. As to the second merits issue, respondent respectfully asked the tribunal to find that respondent 1 complied with its contractual obligations under Article 42 of the CISG. Article 42 states that the interpretation of the disputed clause should firstly respect the intention the party had at the time the contract was concluded. The parties to the agreement between Ross Pharmaceuticals and respondents did never intend to extend it to respiratory diseases. Even though Ross Pharmaceuticals started to support the opposite, once it has discovered the potential of the vectors for respiratory diseases, its behavior after the conclusion of the contract proved that Ross Pharmaceuticals knew at all time that such a use was out of the scope of the license. Indeed, almost 4 years after the contract was concluded, Ross Pharmaceuticals offered to acknowledge the license did not include the use of the viral vectors for respiratory diseases in exchange of a non-exclusive license.
Sorry, Miss Emma, if I may, I'm not sure why should the tribunal assess the intentions of Ross Pharmaceuticals?
The intention of Ross Pharmaceuticals is fundamental because we need to look at the intention of the parties when the contract was concluded in order to know if the scope of the license include respiratory diseases or not. And respondents contend that this could not have been neither Ross Pharmaceuticals' intention nor respondents' intention. Ross Pharmaceuticals tried to bargain a free license in exchange of a license it already has. Moreover, the parties could not have intended to extend the scope of the contract to respiratory diseases, as at the time that the contract was concluded, the vectors were not expected to be used in the field of respiratory diseases. So, should the tribunal consider that the common intention cannot be established, we should look at the reasonable interpretation of the contracts. And here, in light of Article 8.2 of the CISG, a reasonable person with medical knowledge could not have considered the terms malaria and related infectious diseases as covering the use of the vectors in the field of respiratory diseases. Related means belonging to the same group, but COVID-19 does not belong to the same group as malaria or any infectious diseases related to it. Cholera was added as an example, but cholera is closer to malaria than COVID-19. Both diseases are tropical diseases and are waterborne diseases, and both do not generally affect the lungs, which is not the case of COVID-19. The licensed technology thus cannot include the use of the GORADCAM vectors. as COVID-19 has nothing to deal with malaria. Should, however, the tribunal find that respondent 1 did not abide by its obligation, it should nonetheless find that Ross Pharmaceuticals' claim remained insufficient to render the good non-conforming. I see that I'm running out of time. Could I ask for 1 minute more to summarize my argument?
Yeah, at least according to my chronometers, you still have 1 minute. And I think
Yes.
I started at, okay, so please.
Thank you. Indeed, the obligation of the sellers to deliver the good free from third-party right or claim does not extend in cases where at the time of the conclusion of the contract, the buyer knew or could not have been unaware of the rights or claim. But here, claimant could not have been unaware of Ross Pharmaceuticals' claims. Indeed, it was claimant's responsibilities to perform its due diligence of assessing its future license granting history, especially considering that this was a major investment for claimant at that time. Claimant could not have been and should not have been unaware of Ross Pharmaceuticals' claim. Applying the CISG would condone claimant's wish to free itself from this agreement because it no longer serves its interests, as claimant has now a better bargain with its acquiring company. Therefore, concerning the merits issues of the case, respondent respectfully asks the tribunal not to apply the CISG to the purchase collaboration and licensing agreements and to find that respondent 1 did not breach its contractual obligations under Article 42 of the CISG. The tribunal should condemn claimant for trying to free itself from an agreement simply because the agreement is no longer in its favor. This was the end of my submission. Thank you.
Thank you very much. Are there any questions for my co-arbitrators?
I have no questions.
No question.
Okay, so let's move to rebuttal. So Ms. Castro, please have the floor.
Members of the tribunal, opposing counsel relied its argument by stating that claimant had a duty to investigate and could not have been aware of the existence of the pending discussions surrounding the Ross agreement, but has conveniently omitted the fact that its head of contracting department on the day of the conclusion of our contract wasn't directly involved in such discussions. Respondent is stating that they could not have been aware, but claimant was the one who should have conducted an investigation. And members of the tribunal, respondent's contradictory behavior cannot be sustained. Thank you.
Thank you very much. Respondent now, Ms. Zurzolo.
Yes, exactly. Thank you. Claimant will remain to its previous assertion and state that it was claimant's responsibility to perform its due diligence of searching if there were no claim related to this agreement. As for claimant, at the time, this was a major agreement. Thank you.
Okay, thank you very much. So maybe we should finish now, right, Lucas? Because we are on a tight schedule to deliberate and then clear the room. Is that correct?
So yeah, thank you everybody. It was really good. So the 3 arbitrators are going to the breakout room. I'm going to try to put you there. Let's see if it works. I'm going to start with Mariana. Peter, I sent you. Are they gone? Yeah, they are gone. So I'll be back in some time. Thank you, girls. See you.
Thank you.
Congratulations, everyone.
Congratulations.
Congratulations. Thank you for the panel.
Yes, everybody did a good job. Thank you. Thank you, Emma. That was fantastic. Thank you. Emma stepped in for our part. We have a problem with the pleader, and she has never pleaded this part before.
Oh, you did
think-
very well, Emma.
Yeah, I think she did very well.
Yeah, I do agree.
You were both opposing counsel, so thank you.
But yeah, it was very nice. That's good. So how is everything in Brazil?
Everything is fine in the possible manner. We are still in a pandemic here, lockdown restrictions, really hard. And you and friends, how is it going?
Go ahead, Emma or Emma.
Yeah, we have some restrictions as well. There is no lockdown for now, but in some cities there are some local lockdowns, depending on the local situations. But we have all classes remotely. Maybe you have to, yeah.
Yeah, we too.
And we
Yeah.
have
Are you on the same class, you two?
Yes, we enter together in college.
Okay.
And what about you?
Yeah, we are two in the same class. We are doing a master degree. So both of us, and yeah, we are.
Well, we are not dead yet.
We are
Really?
just undergraduate students, yes.
Okay. Wow.
We're almost concluding the course.
Okay.
But the COVID situation is getting worse and worse in France again. I know it's pretty bad in Brazil too. It's terrible. We just can't seem to get a control over it. I'm not sure what's going to happen here. It looks like I'm going to sign off. Huh?
Hello again. I don't know if my fellows arbitrators are with me already here, Peter and Lucas.
I am. I cannot see Peter, but he must be coming back. I am bringing he here.
Okay.
Yeah, it's done. Everything's
Okay.
working.
Okay, thank you very much for waiting. So the panel has reached a decision, and it has decided that UFBA will move to the final. So congratulations to you all. You are all very, very good, and hard work. It's seen and it's obvious how hard you've worked, but the panel decided that it would be Bahia to move on. Okay, so I'm not going to wish you luck because Novi is going to be in the final, so I cannot wish good luck. But well, of course, good luck for you all, and I hope to see you. I'm going to attend, of course, the final. See you.
Just some
Thank you
final
all.
words. I am just sending here at the Zoom chat for everybody I'm sending you my email. I have several feedbacks. If you want, we can talk about it later. I think you all did an amazing job, but today UFBA was a little bit better, and we hope the best of luck on the final today on Vienna and on the career, I am sure, successful career that all of you have before you. So we'll meet again at 2 p.m.
Excuse me, Lucas, is there a third place contest as well now, or how does it?
No third place.
Okay, so you're just going to pick the 1 and 2 in the next round.
Yeah, and
Okay.
as far as I know, we are going to have 2 third places.
I see. Okay.
Okay.
Thank you.
And the link for the final, or just how do we, Lucas, do you know?
Yes, we are going to organize the same way that we did here on this Zoom class, on this Zoom room, but on other YouTube link. So we need to organize everything now.
Okay, so we should go to the yesterday's link. That's what we should do, and wait there for.
Maybe you can wait there. Yeah, I think some information will be over there, but we still need to organize everything.
Okay.
I just need to close this and to liberate the YouTube. Peter, do you have some final words? Okay, so I'm going to end the broadcasting, and once again, congratulations to you all.
Thank you very much.
Thank you.
Thank you.
Thank you. Congratulations,
Good
everyone.
luck. Good luck for the final.